Let's start from Nnamdi Kanu, all the way from the east. The detained leader of the proscribed IPOP group has asked the Supreme Court to quash the ruling of the Court of Appeal, which granted a stay of execution of its order, discharging him of the terrorism charges filed against him by the federal government. How do you read this emerging development, BKO?
Actually, I wasn't expecting the Court of Appeal to set aside its own, not set aside, to stay the execution of its own judgment. Because its judgment was carefully considered. So why would you then stand in the way of the execution of your own judgment? These are some of the things that the judiciary does to itself that prompt many of our people to be worried for the judiciary. The appeal court earlier in the month of October gave a ruling that the way Nnamdi Kanu, who was being tried for treasonable felony and terrorism, was brought into our country, was in contravention of both local and international laws. And for that reason, the appeal court went ahead to to quash the charges brought against Kanu, for which he was being tried by the Federal High Court, Justice Binta Murtala Yaku. After the judgment, naturally, the government was worried, and the government didn't exactly know what to do, whether to simply appeal the judgment or release Nnamdi Kanu the way the way the appeal court had directed. But instead of appealing to the Supreme Court, which Kanu's lawyers will have opposed, Kanu's lawyers will have asked for his release more than anything, the Attorney General, who had first argued that Kanu was acquitted, was not discharged, decided to approach the same Federal Court of Appeal that released Nnamdi Kanu and asked for a stay of his own judgment. As far as Nnamdi Kanu's lawyers are concerned, what the appeal court did in respect of his own judgment amounted to shaming the judiciary, because it amounted, in their own views, to setting aside his own judgment even before the apex court of the land had entertained the matter. As far as they were concerned, the appeal court erred in law by granting a stay of execution of his judgment in respect of a criminal matter. They also argued that the appeal court did not evaluate the objection of Kanu's lawyers to the application brought before the court, asking for a stay of the execution of that judgment before he took the decision to stay the execution of his own judgment. So, as far as they are concerned, it amounted to what the appeal court did amounted to overruling itself, giving a judgment, and then by its own self overruling itself, setting aside its own judgment. That's what this amounts to to Kanu's lawyers, and they have then decided to approach the Supreme Court to set aside that decision of the appeal court, staying the execution of a judgment that it freely gave. So this is where we are on this matter. And some days back, there were protests in a part of the Southeast in which IPOB members actually threatened that there will not be an election in the Southeast if Kanu was not released. This whole matter, just as some Southeast governors said the other day, and I'm in agreement with them, that this matter is not beyond a political solution. It's not beyond a political solution at this stage. There are many benefits that could come from a political solution on this matter. I know that the government would not want to release Nnamdi Kanu at this stage, but they have not handled the judicial matter well. And the law is the law. If you do not build your case properly, then your case will crumble. It's like somebody building a house. If you do not build a house on a good foundation, of course, the house will give way in no time. So, from the legal standpoint, the case that they brought against Kanu was not watertight, because to bring somebody from Kenya in the way that they have done, that person needed to go through an extradition trial. Kanu did not go through an extradition trial. He was smuggled into Nigeria in a manner that breached his fundamental human rights. And his lawyers simply argued, citing both local and international laws. And the laws of Nigeria do not extend beyond the borders of our country. So you can't go to another country and simply drag a man out of the country and bring him here for trial. It negates local and international law. And it was on the basis of that the appeal court decided to let him go. And don't also forget, even when they said that he installed a transmitter somewhere in the Southeast to broadcast anti-Nigerian messages and all that, his lawyers argued that if indeed that was the case, then the court in Abuja does not have jurisdiction over something that happened, over an offense that was committed in the Southeast. So, on the from the judicial point of view, they have the Federal Ministry of Justice, the Attorney General and his team have done a shoddy job, and no one can blame the appeal court for dismissing the matter in the way that it has done. And now we wait to see how the Supreme Court will respond to this matter. Ozekome, Kanu's lawyer, had decided to go to the Supreme Court ahead of everyone. Now we'll see how the Supreme Court will handle this matter.